and welcome to the first meeting of the Florida Commission on Access to Civil Justice. You all know me as the Chief Justice of the Florida Supreme Court, but today I am speaking to you as the Chair and fellow member of this vitally important commission. First, I thank all of you for your willingness to serve on the commission and for your commitment to working together to develop strategies to overcome the impediments that many of our fellow Floridians face when seeking access to civil justice. Your ideas and voices as members of this commission and your enthusiasm and efforts will ensure that the commission's mission to study and address the remaining unmet civil needs of disadvantaged, low-income, and moderate-income Floridians is accomplished. I want each of you to know that your input and dedication to the important work of this commission are appreciated, not only by me, but also all of those who will benefit from the commission's work for many years to come. Looking around, I realize how fortunate we are to have members who represent all three branches of government, as well as the private sector. You have been selected based on your experience with the Florida justice system and your commitment to the Commission's mission. This gathering of leaders from across our great state offers a diversity of perspectives and expertise that will enable the Commission to meet its overall goals and objectives. By way of a beginning, I thought it would be helpful to briefly discuss the creation of this commission and explain the general mission of the commission. Why was this commission created? I am sure many people have asked you that over the last few months. In short, this commission was created because the American and Florida judicial systems are founded upon the fundamental principle that justice should be accessible to all persons, regardless of economic status or disadvantage. However, this fundamental principle is, for some, nothing more than a theory. Regrettably, some Floridians encounter barriers when seeking access to the civil justice system. Through a variety of means, the Florida courts and other entities within the Florida justice system have endeavored within their respective scopes of authority to improve the availability and delivery of legal services to lower income, disadvantaged, and self-represented individuals. However, despite these noteworthy efforts, Floridians continue to encounter barriers when seeking meaningful, informed access to civil justice. Furthermore, at the root of the access to civil justice problem is a broken system. In criminal cases, as we know, legal representation is guaranteed by our Constitution. But in civil cases, like family matters, home ownership, landlord-tenant, and veterans benefits, there are no guarantees. The Florida Commission on Access to Civil Justice is designed to serve as the umbrella organization in our state for efforts to enhance access to civil justice. The Commission will study the remaining unmet civil legal needs of disadvantaged, low-income, and moderate-income Floridians and make recommendations to the Florida Supreme Court on strategies for eliminating barriers to civil justice. My fellow members, when studying the remaining unmet civil legal needs in our state, the Commission must consider Florida's legal assistance delivery system as a whole. That is, we need to take a holistic approach that takes into account staffed legal aid programs, resources, and support for self-represented litigants, limited scope representation, pro bono services, innovative technology solutions, and other models and potential innovations. As chair, I want this commission to build on the great work that others in our state have started and have been working hard to implement with limited resources. Our local legal aid societies, despite resources stretched to the limit, have been there all along, representing folks who would otherwise not have access to our civil justice system. Members of the bar have donated countless pro bono hours a year to needy citizens. Judges and court staff have been doing what they ethically can to assist those coming into the court system without representation. But now we, as commission members, must take it to the next level, bearing in mind that access to civil justice is a societal concern, and as such, the solutions rest with all segments of society. At today's meeting, we will be introduced to information about self-represented and unrepresented litigants who do not currently have meaningful access to the civil justice system. We will hear from panelists who will drill down into the gap that needs to be repaired. The panel will share real-life examples, describe some of the obstacles faced by those seeking help, identify the most requested areas of need, and talk about the challenges in responding to the need. There will be a slide presentation providing you with an overview of the history and accomplishment of access to justice commissions in other states. Our keynote speaker, Chief Justice Nathan Hecht, will explain how the Texas Commission got started and share lessons learned and the achievements of that commission. The potential of this commission is extraordinary. For working people, in working together, we have the opportunity to change the lives of Floridians. With our dedicated members and support staff, this commission has the tools, knowledge, and ability to bring everyone together and enhance access to civil justice in our state, which will not only have an enormous effect on the lives of countless Floridians, but both now and in years to come, but will also allow our courts to operate more efficiently and effectively. Our first presenter is Mr. Paul Hill, the General Counsel for the Florida Bar. He will be providing a brief overview of public records requirements as they relate to the Commission and its work. Mr. Hill.
Thank you, Mr. Chief Justice, and good afternoon. And I congratulate all of you on this very important public mission that you are about to undertake. I'm happy we've got good weather for you in Tallahassee, and my remarks are indeed a little bit about sunshine and public obligation. I've given you a little one-pager. I'm sort of an admin preface to the main event, so I don't want this warm-up act to be a wet blanket. But for some of you public members, welcome to public life, at least as the state of Florida envisions it. You are a creature of the Supreme Court of Florida, and the Supreme Court of Florida, as well as our entire judicial branch, is subject to a constitutional public records obligation in the Florida Constitution. It basically says that any document record that you may make or receive in the course of your official business on this commission will be a public record. We want the public to follow you, but we don't want you to be stalked. We have a protocol in place, and you will learn more about it from your good handlers. The Florida Bar is performing a secretariat function for this group. And first and foremost, our message to you is anything you receive in the course of your activities on this commission, please share with your commission staff. Anything that you may send out in the way of messaging should also be shared with that staff. If those protocols are in place, we think your tenure on this committee will be an enjoyable one. We are already receiving requests about your activities, and we are handling them expeditiously. As you crank up, you can imagine we will have more interest in what you do, and more individuals may want to know about your activities. We don't want to come to you and double check to make certain that you have not overlooked materials that are known to us. If those activities go well, you should have a wonderful and enriching experience. And I wish you well in those endeavors. Thank you very much. Any questions? Thank you, Mr. Chief Justice.
Thank you, Mr. Hill, and thank you for the informative overview of the public records requirement concerning commission matters. Now we have an opportunity to learn something about the dedicated group of people who we will be working with through a narrated video that introduces the commission members.
Commission members of the Florida Commission on Access to Civil Justice. The Honorable Jorge Labarga is chair of the Florida Commission on Access to Civil Justice. He became the first person of Hispanic descent to lead Florida's judicial branch of government when he was sworn in as the 56th Chief Justice of the Florida Supreme Court. He received his JD from the University of Florida Levin College of Law. After spending 17 years in private practice, he served as a 15th Judicial Circuit Court judge and on the 4th District Court of Appeal before being appointed to the Supreme Court in 2009. Ramon Abedin is president-elect of the Florida Bar. A partner in the Sedgwick law firm, he has tried cases in both state and federal courts in Florida representing multinational corporations and insurance companies. He is a lifetime fellow of the Florida Bar Foundation and a past president of the Cuban American Bar Association. He is a graduate of the Loyola University New Orleans School of Law. Alexander Acosta is Dean of the College of Law at Florida International University. A native of Miami, he was a law clerk for Justice Samuel Alito, then a federal appeals court judge. He served in 3 presidentially appointed Senate-confirmed positions and went on to become the first Hispanic to hold the rank of Assistant U.S. Attorney General. He earned his law degree from Harvard Law School. John Attaway is the Senior Vice President, General Counsel, and Secretary of Publix Supermarkets. He joined Publix in 1997 as corporate counsel to create Publix's first corporate legal department. Prior to joining Publix, he was a shareholder with Lane, Trone, Bertrand, and Vreeland. He's a graduate of the Stetson University College of Law. The Honorable Jeff Atwater is Florida's Chief Financial Officer, State Fire Marshal, and a member of the Cabinet. A fifth-generation Floridian, he was elected to the Florida House of Representatives in 2000 and to the Florida Senate in 2002. He was Senate President in 2008. He earned his bachelor's degree in finance and an MBA from the University of Florida. His private sector experience includes 25 years of community banking. Martha Barnett is a retired senior partner of the law firm of Holland & Knight. Her primary areas of practice were administrative, governmental law, and public policy. She was president of the American Bar Association in 2000 and 2001. She was the first woman to serve as chair of the American Bar Association House of Delegates. She is a graduate of the University of Florida Levin College of Law. The Honorable Pam Bondi, a native of Tampa, is Florida's 37th Attorney General. A graduate of the Stetson University College of Law, she served as a prosecutor for more than 18 years. She was awarded the Distinguished Alumna Award in 2011 for extraordinary service to Stetson law and to the legal profession. She serves on the board of the Spring, Tampa's domestic violence shelter. The Honorable Rob Bradley was elected to the Florida Senate in 2012, representing Alachua, Bradford, and Clay counties. A graduate of the University of Florida Levin College of Law, previously he was an assistant state attorney and special magistrate and a member of the Clay County Commission. He was named the 2014 Legislator of the Year by the Conference of County Court Judges of Florida. The Honorable Nikki Ann Clark is a judge on Florida's 1st District Court of Appeal in Tallahassee. Before her appointment in 2009, she was a circuit judge in Florida's 2nd Judicial Circuit for 15 years. She was on the Florida Supreme Court Committee on Families and Children from 2004 to 2014, serving as chair from 2006 to 2010. She is a graduate of the Florida State University College of Law. Gregory Coleman is president of the Florida Bar, a graduate of the Stetson University College of Law. He has been practicing law in Palm Beach County for more than 2 decades. He is a partner at Critton, Luthier & Coleman, where he concentrates his practice in complex commercial litigation. Active in professional associations throughout his career, he is currently a director of the Florida Bar Foundation and a delegate to the American Bar Association House of Delegates. The Honorable Timothy Corrigan has been a United States District Judge for the Middle District of Florida since 2002. From 1996 until 2002, he was a U.S. Magistrate Judge. He spent 14 years in private practice with the Jacksonville law firm of Bedell, Dittmar, DeVault, Pillins, and Cox. Corrigan received his law degree from the Duke University School of Law. He is a board member of Daniel Inc., which provides services to at-risk children. Jeff Craigmile is chief counsel for Walt Disney World Resort. He has worked as an attorney for the Walt Disney Company for more than 23 years. As chief counsel, he is responsible for all legal matters at the Walt Disney World Resort, the largest single-site employer in the United States with more than 70,000 employees. He earned his law degree from the University of Virginia School of Law. Marshall Kreiser III is Chancellor of the State University System of Florida. A former president of AT&T Florida, he has served as chair of the Florida Council of 100, the Florida Chamber of Commerce, and Florida Tax Watch. He is presently on the board of directors of Enterprise Florida. A Florida native, he graduated from the University of Florida with a degree in business administration. The Honorable Linda Doggett is the clerk of the Circuit Court and controller for Lee County. She's on the board of directors of the Florida Court Clerks and Controllers Association, serves as chair of both the Technology Strategic Planning Committee and the Comprehensive Case Information Systems Committee, and is a member of the Pro Se Committee. She has a degree in Management Information Systems from Hodges University. Thomas Edwards is the senior partner and shareholder at Edwards and Ragatz in Jacksonville. He is a past president of the Florida Justice Association. He currently serves as a member of the Executive Council for the Florida Bar Trial Lawyers Section, on the board of Jacksonville Area Legal Aid, and on the national board of the American Board of Trial Advocates. He is a graduate of the Stetson University College of Law. Ben Gibson is an assistant general counsel for Governor Rick Scott. Before joining the governor's office in 2012, he was an attorney with the Florida House of Representatives in the Office of the General Counsel and the Community and Military Affairs Subcommittee. He represents the Second Circuit on the Florida Bar Young Lawyers Division Board of Governors. He is a graduate of the Florida State University College of Law. The Honorable Robert Hilliard has been a county court judge in Santa Rosa County since 2005. Before his election to the bench, he was a Santa Rosa County Commissioner. A graduate of the Georgia State University College of Law, he is president of the Conference of County Court Judges of Florida and is a member of the Florida Bar's Vision 2016 Commission. James Kowalski is the executive director of Jacksonville Area Legal Aid. After graduating from the University of San Francisco School of Law, he began his career as an assistant state attorney in the 4th Judicial Circuit, and later he was a civil trial attorney in Jacksonville, specializing in consumer protection litigation. He was a recipient of the Florida Bar President's Pro Bono Service Award in 2009 and 2012. Donnie McKenzie is the president-elect of the Florida Bar Foundation. He is a partner and a member of the litigation department at Holland & Knight in Jacksonville. He is the firm's pro bono partner for Jacksonville and was Holland & Knight's most valuable partner in performing pro bono services in 2006. He was honored with the 1997 Florida Bar President's Pro Bono Service Award. He is a graduate of the Florida State University College of Law. The Honorable Charles McBurney represents parts of Duval County in the Florida House of Representatives. He was elected in a special election in 2007 and has been re-elected 4 times. Previously, he was an assistant state attorney and after that entered private practice. He is a Florida native and graduated from the University of Florida Levin College of Law. Kathleen McElroy is a shareholder with Carlton Fields Jordan Burt in Tampa, where she represents creditors in disputes with commercial debtors. She is chair of the firm's Pro Bono Committee and is a past president and a former member of the board of directors of Bay Area Legal Services. She is a past president of the Florida Bar Foundation and currently serves as co-chair of the Florida Bar Pro Bono Legal Services Committee. She is a graduate of the Washington and Lee University School of Law. Byron Cheney Russell is the chairman and CEO of Cheney Brothers, a food service distributor in the Southeast for almost 90 years. For fiscal year 2014, Cheney Brothers exceeded $1.2 billion in sales. He's the grandson of company founder Joe Cheney and worked for the company as a buyer and warehouse manager before being named CEO in 1981. He is a graduate of Stetson University. The Honorable Bertia Soto is Chief Judge of the 11th Judicial Circuit. She is the first woman and first Hispanic Chief Judge in the history of the 11th Circuit. She has served as a judge in Miami-Dade County since 1997 when she was elected to county court. She was appointed to circuit court in 2002. She spearheaded efforts to establish Court Care, a child care program for those who need to come to court but do not have access to child care, in the Domestic Violence Division. She is a graduate of the University of Miami School of Law. Emerson Thompson Jr. is president of the Florida Bar Foundation, a statewide charitable organization dedicated to providing greater access to justice in Florida. He has been on the foundation's board since 1995. He served as a senior judge for the 5th District Court of Appeal since 2008. Before his retirement in 2008, Mr. Thompson served as a county, circuit, and appellate judge. He is a graduate of the Florida State University College of Law. Robin Hassler Thompson of Robin H. Thompson and Associates in Tallahassee consults with a wide range of organizations including international public policy and human rights advocacy groups. She led Florida's first task force on domestic and sexual violence from 1993 to 1998 and has served on the National Advisory Council on Violence Against Women. She graduated from the Florida State University College of Law. William Van Norwick is a partner with Ackerman LLP in Jacksonville, where he is in charge of the firm's national pro bono program and a member of the appellate practice team. He retired from the 1st District Court of Appeal in 2014 after serving as a judge for 20 years. He is a past chair of the Florida Bar Standing Committee on Pro Bono Legal Services and formerly served as president and member of the boards of Jacksonville Area Legal Aid and Florida Legal Services. He is a graduate of the University of Florida Levin College of Law. Gwen Young, a shareholder with Carlton Fields, Jordan Burton, Tampa, served as president of the Florida Bar in 2012 to 2013. She handles commercial and business disputes, real property litigation including title insurance and real estate matters, as well as probate and trust litigation. A member of the board of directors of the University of Florida Foundation since 2013, she has also served in numerous leadership roles for local, state, and national legal, educational, and community service organizations. She is a graduate of the University of Florida Levin College of Law.
There we go. Now I'm on. I think Coleman did that. And now you have a sense of the remarkable skills and backgrounds and knowledge that commission members are bringing to this important endeavor. Now you have a sense that we mean business. I hope you enjoyed this video introduction to your fellow commission members. At this time, I am pleased and honored to introduce our keynote speaker, the Honorable Justice Nathan Hecht, Chief Justice of the Texas Supreme Court. Justice Hecht is the longest-serving member of the court in Texas history and the state's senior appellate judge in active service. Texas has one of the nation's leading access to justice commissions, and as Chief Justice, he has played a major role in this effort. Please join me in welcoming Chief Justice Nathan Hecht.
Thanks very much, Chief Justice Labarga, and thank you for the invitation to be here. What an impressive commission you have, and what a wonderful start you make in dealing with issues that bring us here. Especially glad to have representatives from the legislature, Chairman Bradley, Chairman Burney, from the business community, from the practice, from legal aid providers, from the courts. These are the constituents that are necessary to begin to address these problems. And also we build on the work of the Florida Bar and President Coleman and the work he has done to help bring about this commission, and also the work that lawyers do every day in representing people who are unable to access the courts otherwise. Texas and Louisiana, like all the states, can't help but be competitive about things. Florida beat us into the Union by about 9 months in 1846. They beat us out of the Union by about a month in 1861. Then they beat us back in by about 30 days in 1867. So we have traded firsts from time to time. I think we taught you a little about basketball last year, but I don't want to raise a sore subject. I think our barbecue is bound to be better. But we have a lot of things in common. We both voted for Bush for president in 2000, eventually. Now we both have access to justice commissions. So let me tell you a little about our experience in hopes that it will help yours with this giant caveat to begin with. And that is all of the states who have gone this way have struggled with different kinds of problems. None has a ready answer. The problems are complex, and we learn from one another. And so we don't, Texas does not have any magical formula for this any more than California, which was the first state with a commission, or in Washington. I think California was second, actually, in Washington, and other states who have tried this. But we do have some history that I would like to share with you in the little time that I have. The Supreme Court of Texas has always had a commitment to access to justice for the poor, and it goes back to the 1980s and before. And some of you who remember back know that we came up with a very controversial idea back then, which was to take the interest on lawyers' trust accounts, which on any particular client account usually does not amount to very much, but added up for all of the accounts that all of the lawyers have over a long period of time amounts to a lot of money. And because the administrative costs of allocating that interest to the account owners frequently exceeds the interest itself, the idea was we would take that interest and use it instead for access to justice. So fledgling programs began in the 80s. Texas had a voluntary one, then a mandatory one. Florida has one. I think now every state has one. They have been challenged in the U.S. Supreme Court twice, and both times the programs were validated by that court. And so it looked as if taking this money, which is doesn't have much other claim to it, and aggregating it, we would be able to fund legal aid programs pretty well for a long time. And basically that has been the case until the most recent economic hard times. In 2004, IOTA funds in Texas were $26 million a year. They're now a little less than $2. And so with interest rates at zero, interest rates on trust accounts do not generate very much money. The only reason they're as much as 2 is because a number of banks in Texas have agreed to pay 1% interest on lawyer trust accounts, even though they're not required to do so. And just as good corporate citizens, and that has generated a little bit of money, but but not very much. And so it has made us sort of come to grips with the need and how to meet it and where to find support to keep it going. Texas thought we were doing pretty well until we had a hearing in the late 1990s, and we invited legal aid leaders from around the country to come to Austin and tell us in a court setting, with everybody having a little bit of time to present their positions, what the legal aid landscape was across the United States, and then particularly what it was in Texas. And it turns out that we had not paid attention well enough to the problems that were developing, and that they were getting worse. The bottom line was of people who qualified for legal aid living at or near the poverty level, only about 20% of their needs were being met. And these are basic needs, civil legal needs, family law matters, children matters, domestic violence. These days, more and more veterans benefits and issues with veterans returning home, children in schools, housing, employment, the sort of run-of-the-mill kinds of cases, but cases that can be barriers to life when you do not have the means to obtain help with those kinds of issues. We had providers that were sometimes at cross purposes. We had the bar, which had done, as I think it always has, very well in trying to encourage the profession to donate time to legal services and to representing clients for free. But I must say we're a little resentful at having the finger wagged at them all of the time and being told that they needed to do more. They might say, with some justification, that we don't expect the grocers to feed the poor for free. We don't expect the home builders to house the poor for free. We don't expect the medical profession to treat them for free. Why should we expect lawyers to represent them for free? But it is part of the noble tradition of the profession that we do that. And as you have heard and will no doubt hear further, lawyers give in Florida and Texas on the order of 1 million+ hours a year to represent the poor for free, and you multiply that by any kind of minimum, modest hourly rate, $100, $200, $300, and you're talking about hundreds of millions of dollars that are being committed to this problem by the bar. And they deserve our thanks for having worked on this as hard as they have. And so you might question, well, then if they're doing so much and it's worth so much, why do we need any more help? And the biggest reason that we need help is for the infrastructure that makes all of this possible. There are lots of lawyers who are willing to represent the poor for free, but they're not going to walk up and down the streets looking for them. There needs to be some way to connect the clients with the cases, to provide training for lawyers who may feel like they're a little outside their area in some of these cases, to answer the phones, to provide forms when they're necessary, to create a system that can organize the inputs into it and make sure that they get distributed to the ultimate users. And that was why we were convinced after that hearing and some discussions among ourselves that a commission like this was critical, because it was the only way to bring everybody together to bring their own input and ideas to the table in order to be sure that the end product was working as effectively as it could. We decided among ourselves at that time that access to justice is important for four basic reasons. The first one, and most important one to the Supreme Court of Texas, and I'm sure to the Supreme Court of Florida, is that it is essential to the integrity of the rule of law. It is simply unthinkable to make access to civil justice condition on private means. It mocks justice to think that there will be a system that taxpayers pay for that only those who can afford it can have access to. It mocks the very idea of justice. And so it's just essential to the integrity of the rule of law. It's humane. There are so many people on whom the law imposes very difficult obligations in probate, as we're all sad to say, in divorce, in family matters, but even in other things, veterans benefits, which is something that has been particularly troubling to us in Texas. The idea that these young men and women should promise to go and risk their lives for us, and then when they get back, we can't be sure that they get housing or jobs or help them with the families that have deteriorated in the meantime, verges on outrageous, and something just has to be done. But then just to make it more economic, there are many studies, maybe some in Florida, but certainly some in Texas and elsewhere, that access to justice improves the community by strengthening its members, and therefore strengthens the economy. And they're just, sometimes I worry that we spend access to justice money making studies like that instead of representing the poor. But if those studies are necessary to convince that that's really a product of the work that is done, then it's money well spent. And that's why it is so important to have members of the business community here to lend their own credibility to this work. And then finally, it's just the noble mission of the legal profession. The bar is not a guild, and lawyers are not journeymen. The practice is not merely a business. There is a profession to it, and it is essential to that that the skills that lawyers have been given be shared with the community. Now, let me tell you a little about Texas. My father used to say, one of his favorite sayings was, it's a wise man who learns from his own mistakes, but it's a wiser man yet that lets the snake bite the other fella. So let me tell you where we got snake bit a time or two, and maybe you can avoid it. First, some things we did right, and that is that you've got to have the commitment of the court. It has to be firm and constant and unwavering and vocal. This is court business. It is squarely a responsibility of the third branch to ensure that that this problem is addressed, and it needs the leadership of the third branch committed to it. As I say, first and foremost, it's really about the rule of law, of which the court is the steward and protector, so it's very important that the court be involved. My friends in the legal aid community says that the court brings clout to the problem, but I say I don't feel very cloutful most days, Chief Justice Labarga, but I do say it brings an advocate for those who have none and a voice for those who otherwise have trouble being heard. And so the Supreme Court's commitment is just crucial. Then the very strong partnership of the bar is crucial, and it can't devolve into the, as I say, the finger wagging and the preaching. Give more, do more, take more free cases. to lawyers who are already strapped themselves and who feel the pinch of economic times as much as anybody else. But it does have to be a rallying of the troops. This is, again, something we do. It is something we know, and therefore it is something we have to be involved in. Lawyers are nothing if not competitive. And so we have found in Texas that rather than trying to shame people into doing more for legal services, it works better to say that I'm doing more than you are because I'm better than you. And then the other side says, well, no, you're not. That's ridiculous. I can do twice that much. And before long, you've got a little contest going, and all in the toward the good end of helping with of legal aid. I met with one of the Tallahassee providers this morning before coming over here. I don't remember the number of cases. She said they had last year, 3,000, something like that. But even in just that little office, $800,000 of legal work done, and 4,000 or 5,000 people, when you look behind the client, helped as a result. That really is just a very substantial help in helping people with those problems. The lawyers can't foot the whole bill for this, and I know there are issues now about fees and how much can be contributed, but they do have to lead, and they do have to show that they are at the forefront of addressing these issues. One of the things I tell legislators when I go across the street to our legislature is that this is money well spent, because for every dollar you spend, you're helping lawyers give away their time, and surely that's a good thing. This is very leveraged. Public money or public help is very highly leveraged in this endeavor because of the willingness of the bar to take that and contribute in legal aid. We needed a commission because we needed to be sure that everybody that there is substantial agreement with all of these ideas. I can say them, but if people don't really think them, why then I've lost my case and I should go on to something else. But if the idea, if instead I just haven't explained it well enough, then it is important to have a commission that shares those views and is willing to say to the public that this is a priority and a must, and we have to get the job done. I've already said it allows for coordination because you're such a diverse group that is here today. It facilitates communication. It makes possible strategic advances. Different sections of the bar, different committees can tackle the problems different ways. In Texas, we have representation of the law schools on the commission to make sure that they are doing what they think is useful and appropriate in encouraging graduates to do this and in educating them that this is part of the profession. It is crucial to have general counsel, people from the business community, in-house corporate law departments who are not only doing this as good citizens, but are also, how shall I say, inspiring outside counsel to join them in the efforts. Their request for help is usually met with agreement. And then we have had to take our problem to the people's representatives because frankly, we thought we could do this ourselves with IOLTA. That was the history, and it just has not proved possible. And so even we probably should have done this a long time ago. Even if we had not asked the legislature for help, we should have told them that this is what is happening, so they would have a longer start on knowing that this problem is out there and it's being addressed this way, and that might not last forever. But at least the current circumstances have forced us to make our best pitch, our best presentation to the legislature, and to try to persuade them of the need. And I will say in Texas, we have had some pretty tough sessions. The 2009 session was about to get tough. The 2011 session was very tough. And even amidst all of that, our most careful legislators with public spending were convinced that something substantial needed to be done for this. And we told them, we're not trying to get in the way of public education. We had the teachers over there, and God bless them, they needed every dime they could get. The highways needed funds. There were plenty of needs to be addressed. This is not the biggest item on the table, but it is a very important one, and so it required us to acquaint the other branches of government with this problem. And we did the same thing in Washington. And Martha and others know that for many years the ABA has gone to Congress and tried to tell them about this, but we really had not done that very effectively with the Texas delegation. And now we have, and I think persuaded almost all of them, if not all of them, but almost all of them, from very diverse political perspectives across the political spectrum, that again, it's just a public need that needs to be addressed. So in all of that, we have the Commission has helped us bring those arguments to the policymakers who need to hear them. And then I've told some of you already, a commission like this helps enlist all sorts of people that you wouldn't imagine would be involved. For example, it was the bright idea of somebody at a commission meeting who was a partner in a major law firm that maybe the firm's IT department would be interested in helping with the IT problems of the legal aid community. In Texas, one of the problems we have, the state is so big that you're trying to have meetings between providers in Laredo and Lubbock, which is a lot further than from here to Miami, and there are not a whole lot of flights, and it's forever to drive. But Skype works pretty well, or GoToMeetings, or any various ways of having a meeting, except people who are doing this work don't specialize in geekiness, and at least that kind. And so it was necessary to get some help on this, which you could buy it and spend money on. But the IT departments in the major law firms said, let us do it. Let us get on the action. The lawyers are helping people for free. We can't do this, help them with the legal work, but we can help them with the IT work. And so the IT departments of the various law firms all got together, and pro bono helped the legal aid providers develop the technology that saved them a lot of money. This is not a public contribution. This is not even much of a private contribution, but it is a real benefit. And so, through the Commission, we were able to address all of these issues differently. You need, of course, organization. I know the bar is helping to be the secretariat for this, and that's good because you need a staff that will help you make sure that the ideas that you have feet. The one mistake you mustn't make is that the problem can be solved, because it just can't. The teacher said, we have the poor with us always. which is not meant to be a discouragement and forget about it, but it's meant to be a challenge to address the issues that they present. And so there are just so many aspects of this. 15 years ago, we would not have thought very much about the problems of veterans returning to Texas. They existed. We just wouldn't have thought very much about them. But now they're dire. We have to switch gears on that and set up specific programs that are designed to help them. We have lost more troops to suicide than to the war. And that's a terrible thing to have happen, and we just have to be sure that it's not happening because we're not helping them return to those that they have been serving. Another thing I would say to you is a little early success is encouraging, so whatever you can do to harvest a little low-hanging fruit would probably be helpful. It's nice to have some victories under your belt. I wouldn't attempt Mount Everest first crack out of the box. It's just better to do some good, and there's so much to be done. And then finally, you need accountability, because one of the things that this effort suffers from is a lack of information, and so it's good to get regular reports from providers. We don't want to burden them with paperwork, but we do want to find out what they're doing and what they need, and make sure that that happens regularly and meaningfully. What did we not do so well in Texas? Well, we underestimated the need for communication and education. People don't know what legal aid is. They just don't know what it is. A couple of sessions ago, I was talking to the Governor's Council office about legal aid, and one of the people in the Governor's legal office thought it was to hire lawyers who couldn't get a job someplace else. It was unemployment relief for lawyers. Legal aid, that kind of makes sense. So now it's not about that. But they said, well, what is it about? What exactly do you do? We just had a press availability a little earlier, and they asked the same question they always ask. What kinds of cases? What happens as a result? Who does the work? What kind of work is it done? Where does this money go? What is it spent on? And those are things that we need exact answers for. And we were kind of like missionaries all those years. We just marched in and assumed that everybody knew that this was the way things ought to be when it needed an explanation. So it is very important to put together a very exact, precise statement of what is being done and why resources are needed. And my experience is that that's just critical in the legislature. You need public information. We need a little good advertising. So in Texas, we didn't know that at first. And then somebody suggested that we go around and talk to all the editorial boards about these problems, and they're very receptive and quick to write that this needs help. I don't know if anybody reads the paper anymore, but I guess you go to blogs or something. But it is important to go to the public and say, this is being done, this is what's happening in your community, this is what needs your help. It is very important to put a face on the problem. It's too easy to abstract legal aid. We didn't know about that for the longest time. There was a story, I believe, in the Bar Journal, in your Bar Journal, or maybe it was on the provider here in Tallahassee's website recently, but there are stories abound of the difference that legal aid makes, and they just need to be told. During the 2011 session in the legislature, we asked a client who had had a domestic violence case to come speak at the press conference for 3 minutes and tell what the pro bono lawyer had done for her. Well, her ex had threatened her with a shotgun, her and her 3 boys. They were living in a very untenable situation. They had gone to the district attorney, who had people lined up out in the hallway every morning, waiting for attention on these same kinds of issues. In desperation, she had turned to a legal aid provider there in Houston who does these kind of cases, and within really just a few weeks' time, they had had a very good result. So there I am standing in the press conference. The chairman of the House Judiciary Committee, the chairman of the Senate Judiciary Committee, a couple of other legislators, 2 of the lawyers from the commission and the executive director, and this lady, Crystal, turned around to us and said, "You saved my life." Well, I could talk all day long and wouldn't say it as much as she said in 4 words. It's pretty helpful that that kind of work is being done. Veterans, the story is always the same. They come back, the home is broken, it's suffered from inattention, it gets worse, there's separation, divorce, child support, desperation, you lose your job, you lose your home, you can't pay your child support, and there's no way out of the hole, and every day it gets deeper. Legal aid lawyers come in and say, okay, say to the spouse, you'll wait on your child support, won't you, because otherwise you're never going to get paid a dime. And besides that, you need to give them a break. Okay, fine. You go to the housing authority or the apartment complex, say, cut us some slack here. These aren't lawsuits. This is just a lawyer trying to help work out the problem. Let's get a job. Let's get some rent being paid. Let's get you back on your feet. Let's get serious about the child support and dig out of the hole that can be done without there being anything about lawsuits or even adversity. And then finally, I just say that one of the mistakes we made is we weren't evangelical enough. We were always preaching to the choir. So we appreciated our friends, and we never went to the other side, what was perceived to be the other side, and said, we've got something to say to you too. And that's a huge mistake, because it just cannot be political. We have just insisted in Texas that this not have any political overtones. It is not a conservative or liberal issue. It's not Republican or Democrat. It is an issue that involves simply addressing nonpartisan issues in a nonpartisan and effective way, and ought to draw us all together. And I am happy to report that that's our current view in Texas, and I'm very proud of everybody who has worked on that to try to be sure that that is the way the issue is understood. It is something that every policymaker in a state can be proud of having done for the people. So I'll close. I don't want to put you behind schedule, and in my court we have a red light that comes on, and I suspect the chief will turn it on here in a second. But just to say that a couple years ago my court went to Laredo. We sit around the state 2 times a year. And afterward we went to a legal aid office, all 9 of us, and each staff member and lawyer took turns tell us what they did and the cases that they worked on. And at the end, I expressed the court's admiration and support for what they had done. And one paralegal said, "Judge, I've been here 32 years, and I love my work, and I think it matters, but sometimes I wonder, does anybody care?" And I assured him, and our being there, I think, assured him that somebody did care, although it's one thing to care in Laredo and another thing to care in Austin, and that's where the real work needs to get done. But we took that back, my colleagues and I, mindful of the importance of living up to the challenge that his life of work for legal aid presented. When the poor of this society come knocking on the door of the Temple of Justice, asking, "Is anybody there? Does anybody care?" we must prove that the answer is yes. And as you meet here to plan and strategize and to grapple with big problems and work for better solutions, you mustn't forget that real people who are really burdened need our help and are waiting for our answers. So today, as you have invited me here and I close, I just remind myself, as I always do, if because of the time I spend one more person escapes domestic violence, one more veteran gets his benefits, one more retiree keeps her home, one more person realizes the promises of the rule of law, which has been my life's work, it will be worth it. And I take it by your presence here, you feel the same way. It's been a privilege to be here. Good luck on all that you do. And if I can ever help, be of help, please feel free to call. Mr. Chief Justice, that's all I have.
Chief Justice Hecht, on behalf of the Florida Commission, I thank you for taking the time from your busy schedule to travel to Tallahassee and share this invaluable information with us. We deeply appreciate the opportunity to learn more about experiences, lessons learned, and achievements of the Texas Commission. Your presentation will be very helpful, I am sure, as we move forward in Florida. Thank you for coming. Our next presenter is Ms. Melissa Pershing. She is the Director of Grants and Developments at the Florida Bar Foundation. Melissa will provide us with an overview of the role, history, and accomplishments of access to justice commissions in other states. Melissa?
Thank you, Chief Justice, honorable members of the Commission, Chief Justice Hecht, and thank you, Chief Justice Hecht, for your explanation about IOLTA programs, interest on lawyers' trust accounts. You may have had a commission before we did, but Florida had the first IOLTA program in the country. And so we have a PowerPoint. This particular commission is not just any commission. I assume everyone in this room has served on a commission or a committee or a task force or a work group. The Access to Justice Commission began slowly as a movement. It's picked up momentum, and it has done so because it's recognized for its results. The American Bar Conference of Chief Justices, the state court administrators, and other major entities have recognized that access to justice commissions are very powerful in their ability to make change. But it's really not just about these large national entities. This commission is here today because of the leadership of Chief Justice Labarga, the significant investment of the Florida Bar and its leadership, and the support of the Florida Bar Foundation. In fact, access to justice commissions have evolved over their 20-year history. The original definition of what made up an access to justice commission was relatively simple when they first began in Washington State 20 years ago. Blue ribbon entities that brought together 3 major stakeholders and others in a coordinated attempt to break down the barriers that stand between low-income people and the judicial system. However, over the course of time and the work of additional commissions, That work has evolved and grown, and those definitions have expanded to involve not just the state bar, the bar foundations, the legal aid providers, but to include law schools, other stakeholders, the legislatures, more recently the business community, tribal courts, and to think most broadly of what access to civil justice is about. And not just for low-income people who obviously face many barriers to the judicial system, but for the many members of our society who are just over income for the provision of free civil legal aid, but who also have no access to the courts. Our courts continue, our highest courts in the country continue to support these commissions. They plan, they educate, they develop resources, and they meet on regular bases. You just heard from Chief Justice Hecht, and one of the things that he talked about was just about how important communications is. If anything, you might say that the commission movement has indeed gone viral. It also includes other countries. The Canadian Supreme Court is calling for the creation of commissions in every province. The country of Australia is studying the same issues that commissions in almost every state in the United States is also studying. These issues not only cross borders, but they have multiple impacts that are both human, political, and economic when you're talking about access to the civil justice system. We talk often about different kinds of folks who have problems accessing the civil justice, whether it's veterans or domestic violence victims. But not only do they have difficulties accessing courts, the impact of not having access has a significant cost to business. 1 in 4 women will at some point in their lifetimes experience domestic violence. And yet, when we talk about the billions of dollars of economic impact in time at work lost and in healthcare costs by domestic violence victims who don't dare go to work or who are hiding, or even the statistics that show that abusers and stalkers use work time to track down their victims. There is a significant economic cost to all of us, to all of our institutions, in addition to the human cost. The current status of commissions in the United States is this Florida Commission is now the 33rd, in addition to 32 other states, as well as the District of Columbia and Puerto Rico. So we actually have a wonderful opportunity here to stand on the shoulders of those who came before us, to learn from them, but to also bring what is uniquely Florida and the perspectives of everyone in this room to what has come before. It is not the case that access to justice was no one's concern in Florida. It is indeed the case that many entities and individuals have spent entire lifetimes either providing services or working together in other committees and groups to tackle this tough problem. But now is the time for those groups to collaborate and coordinate under the umbrella of the Commission, be it the Bar's Pro Bono Committee, the Vision 2016 Committee on Legal Services, the Judicial Management Council's Access to Justice Committee, the Consolidated Pro Se Committee, the Foundation Leadership Study Committee, all incredible leaders doing incredible work with incredible knowledge that can be leveraged by the coordination and integration of all of these efforts. So commissions across the country have been active in many ways, and every commission is different. It depends on what is going on in the state at the time. But their key activities have been an increasing public awareness. As Chief Justice Hecht has said, most people don't know what legal aid is, but frankly, many people don't even know when they have a legal issue, much less how to find help if they even recognize that, and once they find help, how to navigate a complex system. Commissions have also been active in what we call increasing state-level funding, but that has included fee and fine surcharges, cypre rules. It has included increasing volunteers, but not just lawyers, IT staffs, paralegals. The issues around access to justice require the skills and expertise of multiple professions, making the courts more user-friendly. You can create forms and systems to guide pro se litigants, but as long as the system itself is complex and the law is complex, the forms and the systems and the guidance you provide will necessarily of itself be complex. Increasing collaboration and coordination, not just among providers, but also those who work in tandem with the same people that we help, be they healthcare professionals, be they social workers, be they nurses, whoever works with the same clientele that we do, promoting changes in the legal profession, including tools such as limited scope representation, and making sure that we begin early with students in law schools to have that commitment and understanding for lawyers, and addressing related issues, not just when we talk about things that are related to income, be low or moderate income, but the other barriers that lie between individuals and accessing their justice system. It might be language, it might be living in a rural area, it might be transportation, but access to justice goes beyond income. So when launching a commission, and in 20 years of experience, here are some of the lessons learned and exactly the kind of thing we find ourselves doing today. It is the Supreme Court imprimatur that gives these commissions clout. So we hope that most days Chief Justice Labarga does feel cloutful. But it is a degree of independence from the court. And it really speaks with the court's authority, but is also independent. And that the commission membership be leaders and representatives of multiple constituencies, and that the work gets done by worker bees that involve multiple work groups and multiple perspectives. But the keys have been the stature of the people in the room. And from the very beginning of the introduction, it's obvious that this commission has the right people in the right place to do this work in a way that could change the face of Florida for the next decade. Mission and scope in overcoming barriers, that this is about orienting you at your first meeting, and as Chief Justice Hecht said, let's make sure that you can get excited about some short-term successes, and make the way for institutionalization. The hallmarks have already been set, many of the things that I've already talked about, but especially with an emphasis, again, in one of the areas that commissions have found where they were not as effective as they could have been, and that is around communicating. So many commissions now have blogs, they have websites. Florida already has, Florida has a website already, because it's absolutely critical that not only do we gather information, but that we make sure the public and all stakeholders have access to that information. It is also the case that the commission movement has been so powerful across the country that there are resources available to all of you so that you're not really starting from scratch. You have access to incredible sets of information and expertise all around the state. But the American Bar Association has also dedicated staffing and resources that you can tap into the ABA Resource Center for Access to Justice initiatives. You can find out what every other commission has achieved in recent times by going to this website. If you find something that you're interested in and you want to know more about, the one thing about both the commission and the national legal aid community is all you have to do is pick up a phone. And there are incredible projects going on all around the country. You'll begin to learn the lingo. I point out Alabama where it says online SRL pro bono, SRL, self-represented litigants. The use of technologies, unbundled legal services, the development of diagnostic tools. There literally, in New Mexico, is an online triage system that is beginning to incorporate questions developed by psychologists that will help us understand the capacity of an individual to proceed pro se before it connects them with the resources they need to do so, or determines through expert systems that perhaps that individual does not have the capacity to proceed pro se, or their problem is so complex or so critical they need to speak with someone immediately, and it pulls them out of a self-represented system and connects them immediately with a lawyer who can help them. The Access to Justice Commission chairs meeting, other resources and libraries, those are all available to you. Other resources about commissions are at the National Center for State Courts. And resources for commissions, including the U.S. Department Access to Justice Initiative. All of the federal agencies now have an access to justice component, and they look at the need for legal assistance, whether it's HUD, whether it's the Department of Justice, whether it's any federal agency. They understand that access to the justice system and the assistance of lawyers are key for individuals and groups to access federal agencies and the benefits they provide. The Justice Index. This was started 2 years ago to mine data around what they determined to be key indicators of access to justice. It's recently been updated, and they are measuring ratios of attorney access, self-representation, language assistance, and disability assistance as a beginning way to look at how are we measuring this system. Now, we could leave this screen up for a while, and you could begin to add up those numbers. Let me tell you that based on the latest iteration, Florida ranks 43rd. The number 38.1, which aggregates those numbers in terms of an index, and we all know the statistics are only so accurate. But it's the third most populous state in the country that just passed, New York. 43rd is not where we belong. And finally, there's a National Self-Represented Litigants Network. They have a library. There is a legal aid research that is going on in every university, government entity, federal entity, by other commissions, has been aggregated at this site and is available to you. Again, the national meeting, the ABA, brings together the Access to Justice Commission chairs and stakeholders every year. The next meeting is in Austin in 2015. Last year, there were over 200 attendees from 40 jurisdictions, including more than 20 Supreme Court justices. There's the date. Let's put it on our calendars. Use of social media. There is an Access to Justice blog, the latest one posted on January 5th, that actually talks about Florida creating an Access to Justice Commission on all the latest news around corporate pro bono, the New York City Housing Court, what Massachusetts is doing in administrative law, some of the most really top of the news items, really begin to say how much commissions have evolved and how far they are beginning to reach. In California, the commission itself is giving $185,000 grants to multiple entities for the creation of modest means incubators. In Massachusetts, the commission has issued best practices in administrative law. In Colorado, in cooperation with the Colorado Bar, there are standards and trainings for limited scope representation, teaching lawyers how they can be successful providing services to those of modest means. In Maine, a development of a statewide network of public law libraries, public libraries, providing law-related programming and services. And Mississippi, which is about to launch a Partner Catalyst Summit. Finally, I would like to share with you what really is something that's very, I hope will be of interest to you, but the use of technology in the ways that you provide access to justice. The Federal Legal Services Corporation has invested more than $45 million in the last 15 years on pilot projects, proof of concepts, systems that are available and that we can learn from all over the country. There's a national conference that was actually, I got here at 11 o'clock last night from San Antonio, the National Legal Aid Technologies Conference. There's a national technical assistance projects. All 50 states have portals. And most importantly, a seminal document created after 2 years of meetings by business, technologists, corporations on technology, so that this is an area that is very rich for mining in terms of what we could be doing in increasing access to justice and using technological tools. But it comes down to leadership. It always does. So with all of these resources available to you all over the country, and all you have to do is pick up the phone, with all of the expertise in the state of Florida, what it will come down to is each one of you, your leadership, and your ability and capacity and desire to work with all of us to make sure that there are as few barriers as possible to anyone who wants to access and needs to access the justice system throughout the state of Florida. Thank you all for your commitment and your time.
Thank you, Ms. Pershing, for that informative information. In this segment of the meeting, we are fortunate to have the opportunity to hear from William Van Nortwick and Paul Doyle, who will provide statistical and demographic information about pro-se litigants and others who currently do not have meaningful access to justice. Mr. Van Nortwick is a partner with the Ackerman Law Firm in Jacksonville, where he is in charge of the firm's national pro bono program and a member of the appellate practice team. He retired from the First District Court of Appeal at the end of 2014 after serving as a judge for 20 years. Mr. Doyle is the former director of the Legal Assistance to the Poor Law Student Assistance Program of the Florida Bar Foundation and former founding executive director of the Jacksonville Area Legal Aid. Please join me in welcoming William Van Nortwick and Paul Doyle.
Thank you, Chief Justice Labarga, and good afternoon, Commission colleagues. Paul Doyle and I were charged with starting the discussion of the needs for additional access to justice in Florida. We met several times, and as we were finishing up our product, Paul got sick. He's had the flu, he's been in bed for 3 days, and so I'm here to carry the ball for both of us. He sends his apologies. It's my goal to provide you with a quick overview of the unmet needs for legal services and unmet needs for additional access to the court system. I hope to provide time at the end for questions because I would like to try to make this as casual and interactive as possible. If you think of something during my presentation, please don't stop, don't delay your question. I'll be happy to discuss. The better? Sorry. I'll be happy to address questions. I'm used to doing it from the other side, but I think I can deal with your questions. First, as a starting point, access to justice in Florida is part of the Florida Constitution. Court shall be open to every person for redress of any injury, and justice shall be administered without sale, denial, or delay. So it is built into our constitutional system. The gap between legal needs and access is really a gap based on income. People who don't have the money to pay a lawyer don't really have access to justice. And the base problem, if you look at the poor, is that there are 3 million Floridians who live below the federal poverty guideline. And that guideline is significant because that's the basis on which the Legal Services Corporation allow their grantees to provide legal assistance. They establish by rule that their grantees can provide services to those living between the 125% and 250% of poverty guidelines. Now, I think we skipped one. Yes. Most LSC programs limit themselves to the 125% of poverty guidelines, and most non-LSC funded programs have adopted the same screening guidelines. That means that if a single person can make no more than about $14,600 a year to be eligible, or a family of 4, just under $30,000. Now, once you're in the door and you qualify, in 2009, 50% of potential clients could not be served and were turned away because of lack of resources on the part of the legal aid program. That's a 2009 number. Today, that 50% is a very, very low number. My guess is it's down around 20%. Now, historic studies show that a person who's a poor has, 1 in 4 will have a significant legal problem a year. That means that in Florida you have 762,000 low-income people with a significant legal need every year. Nationally, the historic data says that less than 20% of the legal needs of those low-income Americans are being met. And that was in the good times. That was when the foundation, the Florida Bar Foundation, was flush with funds from IOTA money, and LSC was funded at a higher level than they are today. Today, my guess is, and it's a guess in Florida, that it's down around 10% of those legal needs are being met. Now, the availability of lawyers is another way to look at unmet legal needs. In Florida, there is 1 legal aid attorney for every 7,600 low-income persons. And that's based on 403 legal aid attorneys. There aren't 403 legal aid attorneys today. Because of the layoffs, it's a much lower number. And compare that. The general population has 1 lawyer for every 198 persons. So that ratio itself shows you that there's a reason for the gap. There are, it's one thing to be poor or in the middle class, but if you are among a vulnerable population, you tend to have even more legal problems, and your problems tend to be more difficult. Vulnerable populations. We heard Justice Heck talk about veterans. That surprises everyone, that veterans have an amazing number of legal issues that are unmet. But you've got the elderly, veterans, children, domestic violence victims. All of those pose unique problems for lawyers who want to provide access. In addition, if someone doesn't speak English, they're in a rural area with no vehicle, or they're in an urban area with poor transportation, they have barriers to get them to a lawyer or to get them to court. If they're subpoenaed to be in court, they many times can't get there, and then they've got additional legal problems because they fail to appear. All of those individuals require access to justice, and all of them are uniquely underserved. Some data about children. Children have unique needs. 1 in 4 of Florida's children live in poverty. 19,000 live in foster care. 53,000 of Florida's children were maltreated in 2012, with 56% suffering neglect, 10% physical abuse, 5% sexual abuse. 88% of Florida's children to immigrant families are U.S. citizens. I'm going to repeat that. 88% of children in immigrant families, more than 1.1 million children, are U.S. citizens. The elderly. 18% of Floridians are over the age of 65, or they're older. I'm among them. Some of you are among them. 350,000 plus elder Floridians will have emotional, physical, or sexual mistreatment or potential neglect. There are those that go around and prey upon the elderly. Legal aid many times is the only place they can find. They may not even know what the problem is, but they know they've got a problem, and they end up at legal aid trying to learn that they've got a legal solution. Veterans. 10 years ago, I don't think we could say this, but today the legal aid offices are really a gateway. If a veteran's got a problem, it seems like legal aid is the place they can go find solutions to the problem. It's a very practical. There does not appear to be another organization, although you would think there is in the VA, but they end up at the doors of legal aid to address their problems. I think that's because legal aid lawyers, like most lawyers, are good problem solvers, and they're more concerned about solving the problem than anything else. 51% of Floridians are women. 2.5 million of them will experience domestic violence. That's a home falling apart if there's not the availability of access to justice for those women. Then you've got children, women that are homeless. You've got someone who can't go to work. And the ripple effect of that on a family and on a community is unbelievable. You've heard a number of people speak of that, and I think if women in an abuse situation cannot obtain the legal assistance to get themselves out of that situation, then the society is what suffers. They will certainly suffer. Florida also has a unique group of people in the state, and that is people who are here as part of trafficking. It's sex trafficking, forced labor, various types of exploitation. And again, those individuals find their way to legal aid offices who are able to help them get out of their situation. But again, it's a unique set of unmet legal needs. Florida, because of all of the characteristics that are in that first paragraph, it has a higher percentage of trafficked persons than most other states. Now, the type of unmet legal needs is a broad range. You've heard people talking about housing, domestic violence, family law matters, access to health care, other governmental services. A family who is poor or middle income and who has a disabled child who is not able to access services that they should have available many times has to turn to a lawyer in order to get those services. Sometimes they turn to the lawyer to even find out what services are available. And it takes outreach often by lawyers to try to find out what's the real problem here and what government agency should they go to, and is that government agency going to be responsive. Again, a poor or middle-income family who has a child who can't go to school because of a disability, someone has to stay home. Someone can't work. It disrupts the family and disrupts the society. Now, mostly what I've talked about so far is access to justice for the poor. But the middle class have just as large a problem. They're effectively excluded because if you make $30,000 to $40,000 a year, you can't afford to hire a lawyer at the cheap rate that Greg mentioned of $250 an hour. That's just not going to work. Those people are working on the edge, and that sort of hit they can't afford. And they don't qualify for legal aid. There's no safety net for the middle class. In some ways, the poor at least, or the 10% of the poor who can get the services, they at least have that level of safety net. The middle class does not. And their problems are similar to the poor. Landlord-tenant, traffic, sometimes it's a DUI, family issues, consumer issues. And if they don't obtain the assistance, again, it can basically threaten their health, undermine the structure of the family, and put at risk their housing and their ability to be employed. Now, one symptom of the access problem is how many pro se litigants we see in the court system. I think the last number I read is approximately 75% of family cases are pro bono. At my former court, 30 to 40% of appeals have at least one unrepresented party. That's an appeal. How would a non-lawyer have any idea about what to do with an appeal? In short, they don't. But that's where they are. Talking to Judge Corrigan in the federal courts, same problem. Many, many unrepresented people showing up at the court, clogging the court system. And as a result, they not only can't get the results they want, they can't take advantage of the rule of law because, as people here who litigate know, litigation rules are complicated. They're not easy to work your way through. So a non-lawyer is really helpless. And the judge and the court system is more or less helpless because they can't favor one side or the other unless we have rules that allow the court to take certain actions. I'd like to spend a couple of minutes discussing a recent Supreme Court case that, in my view, creates some interesting opportunities. Turner v. Rogers was decided in 2011. And in that case, the Supreme Court established due process rights of the self-represented, and they spelled out what courts must do to ensure pro se parties have due process rights. In that case, a man was sentenced, incarcerated for contempt of court for failure to pay child support. He was unrepresented. He appealed on the grounds that he was unrepresented, and therefore he had a lack of due process, and he was in jail as a result of that lack of due process. His claim was rejected by the highest court of South Carolina, and the United States Supreme Court accepted jurisdiction. In an interesting twist for appellate law geeks, during the briefing, the Solicitor General, who represents the United States of America, argued that the court should reject the self-represented litigant's claim that he should have a constitutional right to counsel in a civil case, but it should also reject the claim of the other side that the matter should be affirmed. The Solicitor General urged that although there was no right to counsel, or should be no right to counsel as a matter of constitutional law, the failure to follow available alternative procedures in the court meant that the litigant did not receive due process of law. The Solicitor General, the court agreed with that, 100%. Not 100% of the court, but they agreed 100% with the Solicitor General. And the court explained that they had to determine the dictates of due process by examining the distinct factor that the court has found useful in deciding what specific safe grounds the Constitution requires to make a civil proceeding fundamentally fair. It looked at those factors. What is the private interest that will be affected in the proceeding? What is the risk of an erroneous deprivation of a property interest? And what is the nature and magnitude of any countervailing interest in not providing additional or substitute procedural requirements? As the court said, the Solicitor General pointed out that there is available or was available in South Carolina a substitute procedural safeguards which, if employed together, could reduce the risk of a deprivation of liberty. Those safeguards, and this is a quote from the court, those safeguards include notice to the defendant, the use of a form that the defendant filled out to elicit relevant financial information, and the opportunity at the hearing for the defendant to respond to statements by the other side, and it required an express finding by the court that the defendant has the ability to pay. The court then said the record here indicated that the defendant didn't receive counsel, didn't have the benefit of alternative procedures, and therefore found that his incarceration violated due process. Now, originally, the parties seeking the Supreme Court to get involved here were disappointed by the case because they wanted the court to find a constitutional right to a lawyer in a civil case. But when they started thinking about it, they realized that what the court has done is told trial courts, you can't just process these people through the system. You have to build in it certain safeguards so that they have due process of law. And they spelled out that you have to look at the type of case it is. And in this particular case, the issue was the husband financially able to pay child support? That issue was never addressed. And the court said you have to tell them that that's an issue. You have to elicit the information. And this is the court taking the information, not a lawyer. And you have to then make a finding that there is an ability to pay. So Richard Zorsa, who you just heard quoted a minute ago, has a blog on self-representation. And he says if access to justice commissions are empowered by Turner and state leadership to expand their role in reviewing and changing the accessibility of the system as a whole, this case will be seen as an institutional game changer. So I think that there are many ways to skin this cat, and looking at both access to a lawyer and court procedures are two ways that I think may lead us to a better result. I think do I have time for any questions? Right. Anybody have a question? Chief?
Anyone have any questions? Thank you, Mr. Van Norwick. Before we break, earlier this year, I had the privilege of being invited to speak during the swearing-in ceremony of about 75 naturalized citizens at federal court. And after the federal judge swore the 75 people in, he allowed each one to make a brief statement. He passed the microphone around, and he finally reached an elderly Nigerian gentleman. And he spoke eloquently about his admiration for this country's rule of law. He did not have that in his country, had it here. And in thinking back about his great speech, his eloquent speech about that, I wonder how many people in this country see the rule of law only as something in theory that only the people who can afford it have it. And the Nigerian gentleman spoke about how he was in shock in living in the United States that one could go into a court of law and actually challenge a traffic citation by a police officer, or being allowed to speak at a county commission meeting in opposition to something being presented. We take that for granted in this country, that we're allowed to do that. It's not the case in many countries, and I just wonder how many people in this country feel that it doesn't exist for them because they don't have access to it. So without food for thought, we're going to take a stretch break and for about 10 minutes, and let's be back here on 2:30 or so. Thank you.